Okay. Good morning, everyone. My name is Antonia, and I'm a family lawyer here at Leap Family Law. Welcome to today's session, Property Settlements Post-Reform. It's insights from the Family Law Amendment Act 2024 and Shinohara. This session will examine how the court's approach to property settlements has evolved following the commencement of the Family Law Amendment Act 2024 and the full court's decision in Shinohara. We are very fortunate to be joined by three esteemed practitioners to provide some insight into the topic. Liz Coford is a partner at Lander & Rogers in Melbourne and an accredited family law specialist. Liz holds a Master's of Law, specialising in tax from the University of Melbourne, and has a special interest in commercial and tax law issues relating to complex family law property cases. Liz is recognised in several categories in the Doyle's Guide, being ranked among the leading family and divorce lawyers in Australia. Joining Liz is Dara Isaacson, a Victorian barrister who comes to the bar with extensive experience in family law and related jurisdictions. Prior to her call to the bar, Dara was a senior associate at Lander & Rogers. She has particular interest in financial matters involving property development aspects, as well as complex superannuation issues. Dara is also an accredited family law specialist and an accredited mediator. We are also delighted to welcome Dr. Elizabeth Pearson, Special Counsel at Barkis Doolan Winning Family Lawyers. Prior to joining Barkis Doolan Winning in 2023, Elizabeth advised in the public and private sectors on law reform and policy development for more than 10 years. Elizabeth holds a Juris Doctor from the University of Sydney and completed her PhD in law at the University of Sydney in April 2025, where she received the Walter Reed Memorial Fund Award for her studies. The facilitator of the session will be Professor Patrick Parkinson AM. Professor Parkinson is an Emeritus Professor of Law and a former Dean of Law at the University of Queensland. He is also Special Counsel at Watts McRae Lawyers. Professor Parkinson served from 2004 to 2007 as Chairperson of the Family Law Council and also chaired a review of the Child Support Scheme in 2004 and 5. He was President of the International Society of Family Law from 2011 to 2014. Please join me in warmly welcoming our speakers. We look forward to your insights.
Thank you. Good morning, everybody. It's lovely to be with you, and thanks to Leap for organising this. Just some comments, if I may, to begin with, to bridge the two sessions. Whenever you change the statute, there will be intended consequences and there'll be unintended consequences. I wrote a paper on the Family Law Amendment Act, which is what we're going to be talking about today on property, predicting Shinohara, predicting the Rob and Rob issue, because both of them seem to me to flow from the changes to the text. And it's very dangerous, I think, sometimes to say that you're going to codify, and then you don't codify quite right. We saw that in the Family Law Amendment Act 2023 in terms of reopening final parenting orders, didn't we? That there was a significant gulf in the end between the language of the statute and the case law which it was intending to codify. And these things can happen. I expect we'll see more of these sometimes intended but sometimes unintended consequences of the legislation. And that's so after we had exposure drafts. That's the interesting thing. Some of these issues only emerge once people begin to think about the final version of the act as passed, and yet so many of us had an opportunity to think about it and comment on it as an exposure draft, but we're not really concentrating at that point. You know? It's only when you get the case in front of you that you think, oh my goodness, what has happened to this area of law? So these are the hazards of legislative amendment. Now, what we're going to be doing today is we're going to be looking first at the big picture of what is the impact of the property amendment changes, the Family Law Amendment Act 2024, or the June 2025 amendments, depending on how you like to think of them. What's the big picture of how this has changed practice? Has it? Will it? Then we're going to drill down into Shinohara in honor of Gary Watts to say, how are we dealing with this change? And then we're going to look at specifically how we run domestic violence cases in the light of these changes in a property case. And then we'll pick up any other issues as we go. But first of all, we're going to get you to do some work. You have an examination. If you get less than 50%, you lose your practicing certificate. I just thought I should warn you about that. Can we bring up, please, the first poll, which is, have you observed changes in property settlement outcomes following the enactment of the Family Law Amendment Act 2024, either in negotiations or court decisions? And you have a way on Slido of providing an answer. Could I give you a couple of minutes to do that? You need to click on the QR code, join with that number, and then put forward your point of view. Thank you. I think we've probably given long enough for that particular poll. And we're looking at nearly 50% saying some changes. That's no great surprise. But note, only 15% so far saying that the changes have been all that significant. Well, we're going to unpack that, I think, in all sorts of different ways. 5% are saying no change. You've been asleep for the last year. But I mean, that is an interesting thing too, isn't it? In a discretionary jurisdiction, you can muck with the contribution factors, the considerations, and ultimately, it may not change much on the ground. That's one of the other interesting aspects of family law. And too early to not enough data, 17% quite understandably saying, hey, it's too early to say. We're waiting for the line of judicial decisions. Well, let's go to poll number 2, which is just on Shinohara. And how are you coping with Shinohara? How are your therapy sessions going on Shinohara? And the question is, what is your most common strategy in dealing with the removal of add-backs from the balance sheet post-Shinohara? Are you trying to see it in terms of contributions? Are you trying to see it in terms of future needs, sections 795? Are you avoiding add-back arguments entirely? Are you still working out the approach? I suppose there is another one. You're hoping like mad that another full court will overturn Shinohara or the High Court will step in. Nah. But it is a funny thing, isn't it, about family law? You get one bench of the full court, which, if it's minded to make a change to the law, and we had that in the first session as well, can significantly change things. And another 3-member bench would have a different view on the same issues. So there's a certain serendipity about the way in which we devise the law. In the old days, and I mean the really old days, back into the medieval period, you'd have a full bench of judges. All the common law judges would discuss an issue before they reached a decision. That disappeared somewhere in the 15th century, I think. But it's interesting how we deal with these sorts of issues in terms of process. So far, the answers are 60% moving issues to contributions, 38% focusing on future needs, 7% avoiding add-back arguments entirely. If you haven't hit a case where you've got interim property orders or whatever, you may not need to. And they're still working out the approach. Now, we had the formal introductions of the panel, but we've got 2 Liz's on the panel. So on my left is Sydney Liz. On my right is Melbourne Liz. And the first question goes to Sydney Liz. And that is, let me bring it up. In what ways, if any, do you think outcomes in property cases are now different as a consequence of the Family Law Amendment Act, either in negotiated settlements or judicial decisions? I'm going to ask Liz to respond first, but then we can invite the others.
Thanks, Patrick, and good morning, everybody. As Patrick said, we've had about 9 months now to really live with and start to digest what the 2025 amendments really mean. And there are teething problems, as we all know, with any reform, let alone something of a bill that's this size, almost 100 pages, not one but 3 explanatory memoranda. So trying to get your head around that as a practitioner and then explain to clients coming in the door why all of a sudden the law has shifted is a constant task that we're all grappling with, really. Some of the effects of the legislation, particularly with judicial outcomes, are going to take a while to trickle through. But there are certainly some immediate impacts that I've seen and that the panel have seen in our practice that we'd like to share with you this morning that seem to be really a common experience. When you look at the second reading speech for the bill, you can really sum up the changes in 3 themes. The first one was codification, as Patrick mentioned, but I'll call it purported codification because it attempts to codify at least 4 very different areas of the law. Whether it has done that effectively, I think is open to argument, and certainly some of the cases that we've seen subsequently, including Shinohara, would seem to indicate that codification has not been so successful at first instance as we might have hoped. That's not to say that it might not even out in the wash and we might get further authorities that bring clarity there, but that was really one of the goals. Another goal purportedly of the reforms was to bring clarity and accessibility to the law. Again, question mark as to the effectiveness of that. And the third point was really to centre the economic impact and significance of family violence in property cases. So bearing in mind what those kind of 3 thematic goals were, looking at immediate impacts in practice, I think it's fair to say that there's certainly been a renewed focus on what is the text of the law. We've had to go back to the amendments, look at the text, purpose, context, go through that exercise because of the change. So in terms of trying to bring a focus back to the statute and moving away from relying on the common law that used to sit behind it that we were all familiar with, I suppose to some extent that has been a change. Certainly there has been a change in terms of an increased focus on family violence, economic violence. I'm increasingly finding that clients, because of the publicity that sat around the reforms and the fact that it happened at a point in time when we're having a national dialogue about coercive control, increased understanding of what economic abuse might look like, what patterns of abuse might look like. The culmination of all of that is that clients are coming in already with a view of how their lived experience sits. They might have heard about the reforms, they might have heard about coercive control. So we're not educating people from scratch. Increasingly, people are coming to us with an idea of how they think their lived experience might sit, and we're having to provide advice in terms of whether or not that aligns with the legislation and the words specifically in the amendments and the nexus to contributions or future needs that live there. So whether or not ultimately the reforms will lead to judicial outcomes or matters that reflect a greater prominence on family violence, it's too early to tell. But certainly from a practice perspective, to the extent that the Parliament was trying to focus on economic abuse and family violence, I think that aspect has certainly been an immediate change and a significant spike in the discussions that we're having.
It's just a follow-up. The Act does not allow you to award damages for family violence. To what extent do you think clients are coming in saying, I want damages for family violence? They may not use those words, but how much do you think that is the perception that this is what the Act has done?
Look, I think there's certainly a part of that, and I think there's certainly a sense that people are resonating with hearing that happened to me, or that reflects something that I can identify with in my life. So they're latching on to possibly descriptions, for example, that might now appear in the economic or the financial abuse definitions in the Act, or they might recognise some of those things, but that doesn't necessarily mean that what they have experienced is family violence in the sense of a defined statutory term that had an impact on their contributions, for example. And you're completely right. The understanding is to, even if I have experienced this, as traumatic and horrible as that is, there is a misunderstanding, I think, as to what that might equate to in a family law property proceeding.
Because the Act is actually very carefully drafted around this to focus on financial impacts. We're going to talk about this a lot more, but that might be discordant from the expectations people have coming in. Thank you, Liz. Dara.
Can I just add something to that? Because I think it's an interesting point. There's a case of Grano, which is a 2026 decision of Judge Beckhouse. There's a paper where the citations are identified, but it was an interesting case where the issue in that case was really post-separation family violence. There was a slew of issues where the husband had been, effectively, he'd gone to jail for breaching an ADVO. He would show up at the mother's house after separation, tried to steal the dog and the youngest child. He would, on another occasion, the mother was trying to prepare a rental property for sale, and he would show up. And what Judge Beckhouse did in that case, and interestingly in this case, one of the issues of family violence was the mother said, the husband has failed to file his tax return. What that meant is that she was unable to claim the child care subsidy, so she couldn't put the children in after-school care. That meant she couldn't then go to meetings at her work because she had to pick the kids up. And ultimately, Judge Beckhouse looked at family violence in the context not just of the sort of Kennan contributions argument, which she said, yes, contributions were more arduous post-separation, but also the current and future economic circumstances of the mother are very much impacted by the family violence as well. Can I say, I've been saying for years that the best thing that anyone can take out of a relationship is their ability to earn income. And so I think, for me, the leaving Shinohara aside and all of the rest of it, how we deal with family violence is really instrumental and fundamental in how we're now looking at these cases.
But just on that, the judge could have dealt with the failure to file tax returns impact upon the wife without going anywhere near family violence. Couldn't, you could do that under Section 7520 under the old law.
She could have, but I would say that it's a lot easier now. Interesting in that case also, she focused on the fact of the husband's delay in the proceedings and the increase in legal fees, and yes, that's always something that the court would take into consideration, but it's now easier to put it all under that rubric.
Under that rubric. Melbourne, Liz, before we move on to the next question, your experience of changes in outcomes, negotiated or judicial, or is it too early for you?
Look, I think in mediations that I've done in the last 9 months, we have, certainly with respect to the Shinohara issue, found some workarounds. I think there's been a lot of reverse engineering to balance sheets, figure out what the percentage is if you had put an add back section on your balance sheet. But I think aside from that issue, we have seen the way in which family violence is at the centre of cases, I think really has changed. It has, and we'll come to this in a minute, it's probably making it harder as a litigant, but if you are able to kind of stay the course, I think we have seen outcomes both in terms of assessing contributions and the future impact of existing family violence on a party in ways that probably see them leaving with a more appropriate division of the assets than we would have seen previously.
Liz, just sticking with you for a moment, we haven't talked about housing yet, and in Section 79(5), we now have appropriately a focus on the needs of the children in terms of a roof over their heads. Is that impacting? Yep.
I certainly think in interim applications it is. It was never an easy feat to get an interim order for the sale of a property. It's always, when you have a client saying, oh, we can't afford to keep it, neither of us can, let's sell it now. It was never a guarantee that could happen on an interim basis, but I have seen it significantly tightened up. even where the evidence at an early stage does make it clear that neither party, if the property is heavily encumbered, could retain it, there is an absolute disinclination that I've seen, at least in the Melbourne Registry, to go near an interim sale of a property that is the primary residence of the primary carer of children.
So you're seeing an impact from legislation, you think?
I think so.
Yeah.
Yeah.
I mean, we've been dealing with the housing issues for 50 years, right? But we're seeing a shift. Any other comments on the housing issue from people?
No, not necessarily. I think that's right. I mean, it's always been the case that the court will work very hard to try to keep a home, especially if someone wants to keep it on a final basis. But it certainly helps with our arguments of saying that's relevant. I had a case recently where it's pretty clear on the facts that eventually the wife in this case will need to sell the house, but in that case, the wife had 9 Maine Coon cats, which were large. They're large cats. I had to look them up. But one of my arguments that seemed to hold some weight with the court was that she was keeping the family pets, and she wouldn't be able to rent easily in their area without them. So.
That's an interesting point, Dara. I think that the rental changes in a lot of states and territories have come in at an interesting time for the amendments to the Act. It used to be the case, and many of you would have done this, your client has no recent rental history, they just prepay 6 or 12 months rent. That's how they accommodate themselves. In Victoria, that is no longer permissible. Real estate agents probably vary in respect of compliance with, new changes to the Act, and I've seen some workarounds, but I've also had clients applying for upwards of 30, 40 rental applications, unable to prepay despite having healthy bank balances and of getting knocked back. So I think that is probably part of the backdrop against which we're seeing a tightening of interim sales of properties.
Yeah, the whole housing shortage and all the problems. Let's move on to the next question, and sticking with you again, Liz, if I may, and your experience in Melbourne in practice, in what ways, if any, do you think the 24 amendments have affected the cost of litigation for clients? I think we've begun to touch on that. Can you fill that out a bit more?
Yeah, look, I think it's impacted costs both in respect of property and parenting matters, but I think the main stage in which we've seen that has been in respect to the family violence, the centrality of family violence to cases. Evidence is much more significant. You, as a practitioner, need to take instructions about family violence in every case. The case may not have a parenting aspect to it, but you are now asking that question in every case, and I think that the mandatory nature of the considerations in 79.4 and 5 are not necessarily new in the sense that as solicitors we always understand the story of our clients, but whether it's as Liz mentioned earlier, it's in an era in which these issues are very much front and central to people, or whether there's just more appropriate focus on it. But conferences take a long time. People need breaks. People are overwhelmed. I work with a lot of younger lawyers who are, terrific, incredibly diligent, but it takes a long time to be able to interview someone about significant historic trauma. And that, I think, is a real challenge for newer practitioners because the sorts of things that are coming out in these conferences are really big. I think in addition to, the time it takes, obviously, the length of our affidavits is just a constant challenge. We have, rules that sometimes both of which are inadequate for some of the issues, and the thing about having to do, whether it's a 10 or 25 page affidavit, is you often need to do like a 30 or 40 page one to then distill it down. And that is actually much more time consuming than just being given an extra 5 or 10 pages from the outset. I think the financial costs are obvious. There's also the non-financial costs. I've had a couple of cases where there's been significant family violence and we've needed the treater to give evidence. And what that has meant in both of the cases that I had is that therapeutic relationship is lost, which can be really significant for someone. People's books are closed, psychologists and counsellors are very busy and overwhelmed with these cases. So it's not a decision you take lightly to potentially compromise that relationship, but it is a cost, not a financial one, but one that needs to be, I guess, considered.
But that's another unintended consequence, isn't it?
Yeah.
Yeah.
Yeah, look, I know of one case where there was reliance on a single expert who wasn't an existing treater, but that was probably a bit of an outlier. I think for the most part, if you are trying to establish the future economic impact on someone, the only real way you can do that is by relying on what their treater says about prognosis, likely timeframes, impact on full-time, part-time. And sometimes I've had at least one client where the violence was significant, but and I said, look, I think this needs to be the subject of someone's evidence, who's your treater, and you need to kind of go back and talk about these things. And she tried. She went there and she called me and said, I just burst into tears. I can't do that again. She has one child with very significant additional needs and a second child. She's like, I can't drop my bundle like that. Which was really interesting because the evidence that could have come from that sort of a therapeutic exploration is really significant, but she didn't have the capacity to be vulnerable because she was at that stage the sole carer of two children, one with significant disability.
Wow. I did warn the panel that I would ask questions without notice.
I think there's only been 2 on script here, Patrick.
Sydney, Liz, this is a really important discussion about how initial interviews with clients and subsequent interviews indeed with clients has to be more in depth around the family violence issues. And I guess you're thinking mostly of female clients coming in when you talk about that. And I'm wondering, in your experience, when you've got a male client, how are you dealing with that question of exploring domestic violence? Either, could be a recipient a victim of one, or could be a perpetrator, or could be a situation where there's just a lot of arguments which got very heated in the marriage. How are you dealing with that on an interview with a male client?
I think the interview begins the same. The same questions need to be put to the client regardless of the way they identify or their gender. But the difficulty becomes where, for example, you might have counterfactuals with different people.
Yep.
The difficulty also with clients, whether or not they're male or female, is that some are more at a point where they are more willing to be able to talk about their experience. For victim survivors who are particularly traumatised, it can take, as Liz was saying, a very long time to get to a position with their treaters where they're comfortable even seeking legal advice. So that first conference, whether it's with a man or a woman, can be very difficult for those people. There are also different dynamics in terms of some victim survivors are more comfortable speaking with a person of their gender.
Yep.
Others are not. So it's really a case of trying to bring a trauma-informed approach, particularly early on, when you're trying to take instructions so you can understand what exactly is the factual matrix, what exactly is the nature of what people have experienced, and then make a judgment call from a legal perspective as to whether or not it sits within valid categories within the Act. And having a discussion with somebody who is very upset or very troubled by what they've experienced about whether or not they do meet, for example, a nexus between having experienced something terribly awful, but it impacting directly in a way that we can put before the court to change an outcome, that they're extremely difficult discussions to have, regardless of who is sitting at the other side of the table.
Yeah. And how are you dealing with those who might be alleged perpetrators?
Again, very carefully and respectfully, and with a risk hat on high alert the whole time.
Yeah.
But it's really important, as any practitioner appreciates, to try and ask the questions at the beginning to understand exactly where your person is coming from, and to facilitate and to highlight and profile early up what are the risks that we're going to be hit with,
Yep.
including with a perpetrator, and then having to have a discussion with somebody who might be oblivious, who might be defensive, who might be perfectly aware of the effect of what they're doing. Again, they're all very difficult decisions and discussions to have, but as practitioners we have an obligation to advise them on. We can't change anything that they've done or may not have done. That's a matter for them. They're seeking legal advice, and our job is to give it respectfully but as robustly as we can, and to make them understand this is the map forward, this is what the law says, and these are the risks that you're faced with if you move ahead in this way.
Thank you, Liz. And all of that discussion was stimulated by a question about costs, because what we're hearing is it's just taking a lot longer to get the instructions and then put them into affidavits and everything else. Let me bring us to the third question, and Dara leading off on this one. In what ways, if any, do you think the 24 amendments have affected the difficulties of achieving settlements? Melbourne's got a great reputation for settling.
We do. We don't like to lose, so we settle cases we can't win.
We should move Melbourne to Sydney, just...
Yeah, no, yeah, our egos are too sensitive for losses, so. Look, there's two aspects. One is, of course, the Shinohara aspect and what that potentially did for interim property settlements. Obviously, it was always the case since Gable and Yardley that you could adjust interim settlements by the trial judge on a final basis, but when you were acting for the sort of more superior party who controlled the assets, it was easy for you to say to them, okay, well, you hold $1 million, the other side is asking for some, they'll get it, give them $1 million by way of part property payment, and 9.5 times out of 10, it'll get adjusted back at the end. It comes off the top. Obviously, Shinohara sent the cat amongst the pigeons, so for a while we were nervous. I mean, the reality is my advice to my clients was, well, Strawn is still good law, and if they're entitled to a property settlement, you might not get it back, but that's just the way it is. We now have Voight that helps us sort of give some comfort to our clients, but obviously these are issues when clients are looking to us for certainty, and we can't really give it. That's a problem. The other aspect is on how you deal with sort of wastage and that sort of thing. We've all had the cases where after separation, one party has expended a lot of funds or whatever they've done, and there's issues about whether they be added back or not. So that's making settlements more difficult. I have to say, there's a case, again, it's in my paper, of Chambers and Spillett, number 3, which is a Justice Carew decision, which was on a point, it was a modest asset pool, and in that pool, the husband, post-separation, had sold a property and not accounted for proceeds of about $200 and some thousand, and it's an interesting case. The Honourable Justice Carew touches on Watts's paper and says, do I need to examine this issue? But in any event, what she did is she just simply, rather than treating it as an add back, she adjusted more than dollar for dollar in the 79.5 exercise. So in any event, it's making it difficult to achieve settlements because we're all a bit nervous about how the court will deal with things. However, I do think that there's more and more clarity, and we're putting ourselves in a better position to advise clients and to all be on the same page. I will say I had an experience in a mediation not that long ago. It was an interesting case where I acted for the wife. It was a long relationship, and over the years, her parents had contributed most of the asset pool, which at the time was $2.5 million. We were meant to mediate in November. That got delayed, and we mediated about a month ago, and it turned out, before the mediation, we asked the husband for some disclosure. He hadn't provided any, and it turned out that in the beginning of December, he won $4 million in the lottery. And so that was good news for everyone. But what he had done, having failed to tell us about that, was given about $1 million away. And my opponent got to the mediation and said, oh, well, it's now $3 million. it's gone, what are you going to do? And I think that was a bit cute, and we all kind of moved past that. You know, it's not the case that once it's gone, it's just gone. But I suppose it's making cute arguments maybe more possible. And the other, so it is making settlements more difficult, but I think we all just need to sharpen our pencils and, you know, we're not in complete no man's land.
Jo, can I just pause there? So all the things you've mentioned are post-Shinohara problems.
They're all post-Shinohara problems.
The interim property, the legal fees, all those sorts of things making it harder. Is the DV stuff making it harder?
It is, and I want to be very respectful about this because I personally think what we've done with the legislation is a good thing, but it has made things more difficult. I think because previously I as a barrister would get a case that had been prepared for me and my instructions were to run a Kennan argument, and the facts just weren't there, and I couldn't do it. Now it's harder to dismiss Kennan arguments. Maybe that's a good thing, maybe it's not. But the difficulty is when you're sitting at a mediation, and at a mediation we try to resolve things. It's not helpful to say, you know, especially when people are sort of taking on, you know, the advocacy hat for their client. It's hard to sort of press those points in a conciliatory manner. So it is making things more difficult. Potentially, as we get more and more judgments and we see what family violence will convert to, maybe we'll be able to just come to an agreement in mediation so it can be less adversarial.
And look, this is not unusual with changes in family law. You get a period of being very unsettled for a year, 2, even 5 years. But eventually a lot of these problems will be resolved. We need to think about how we deal with legal fees. We've got a body of precedent going back many, many years. But for the moment, costs are up. I think that's been the consensus. Now, it may well be, and this is a technology business which has kindly put on this forum, and it may well be that there will be savings for clients by much more efficient ways of using technology. But for the moment, we're in that interim period where costs are going up. Why don't we turn now to Shinohara, if I could, and some questions there as to how our expert panel is dealing with issues. And who was going to respond to this one first? Was it Melvin Liz? Thank you.
I think that might have been me. Look, we've already touched on the sort of reverse engineering different balance sheets, the decision that Dara referred to earlier where the party that sort of couldn't account for the sale proceeds was essentially dealt with by the other party getting actually more than the proceeds that couldn't be explained. So I think that's going to remain an issue. What I thought I'd talk to you about is how beyond the kind of balance sheet disputes, the ways in which we've been dealing with some of the effects of the amendments, and in particular the use of injunctions. I'd long held the view that unless you really need to bring an application for injunctive relief, you try and avoid it. But when you are unable to, as Dara says, give clients the certainty around, well, look, they've helped themselves to that money, they've bought something with it, we don't need to be too concerned because we're pretty confident that that will be kind of theirs had and received. Without that level of comfort for clients, I had a matter, it's referred to in Dara's paper actually because I was the instructor, where the parties had a kind of loan facility, a mortgage that had been completely paid off and effectively was $1.5 million cash that was available to them and some other assets. And we had a mediation that we were working to, and without telling the wife, the husband took $500,000 of that 1.5 in cash and put essentially a deposit on a business. And I think it was just before a long weekend, 5:30, said, by the way, here's a contract. I've bought this business and I've paid half the money. And so what we were quite concerned about was, and there were a series of sort of concerning attitudinal sort of red flags about this matter. So we said, right, we actually do need to bring an injunctive application with respect to the balance of those proceeds, because they were in an account that he solely controlled. And he conceded he was going to have to agree to an injunction of some sort. And he said, well, I took 500. I'll agree to an injunction with respect to 500 effectively to safeguard for the wife. It was sort of common ground that it would be a 50-50 case. But he said, but I want to be able to access the rest of it because I might need more money for the business. And the difficulty was there was no evidence or disclosure about what this business was actually worth. Had he overpaid? Was it actually worth nothing? And so I think in those cases, we are starting to need to look to, well, how can we preserve our clients' positions if we can't rely on ad-backs? So I thought that was an example that might be of interest to the audience.
Yeah, thank you. Injunctions, and that's one of the other dimensions of all of this, isn't it? Liz, in your practice in Sydney, how are you dealing with ad-backs?
I think my experience certainly reflects the poll that we had earlier and the scattering of responses, that it depends on each case, who we're before, who we're against, and very much a bet hedging exercise to some extent, making clients very aware that this area is in flux, and then trying to make sure that with discussions with the other side, with approaches, with evidence, that you've kind of covered all bases really to an extent. Lots of really delightfully academic discussions with the other side, for example, in the context of joint balance sheets for the court, those exercises about how do we footnote these caveats and this part in the issues list where we're all going to have an argument about Shinohara eventually. But I think being quite upfront with clients that this is a very recent change, that we're dealing with what was meant to be a codification was clearly not a neat, shift and lift. There are real issues that have emerged. We're bound by a current appellate authority that is arguably inconsistent with a previous appellate court authority, but for the moment we've got to do our best and run with it. But this is also something that could turn on a dime and turn on a decision at any point. And
are you feeling like there's been a relatively cooperative approach between lawyers on each side to try to find a way of managing the ad-back issue?
Yes and no. There's certainly universal recognition that it is a live issue, but it has made, for example, trying to negotiate partial property settlements or things of that nature on the timeline to court increasingly difficult, to the point where there have been a couple where the advice has just been, it is not worth spending the money right now to have that fight with the other side or to argue about it. Giving that cost advice to the client can decide, okay, this is the point where I will die on that hill, because it's just coming back to that question of cost. More cost in advising, more cost in arguing a point, even if it's just letters going to and back to the other side about what we're calling, are we putting this in the balance sheet document somewhere? What are we doing with this? That's all running up cost. Talking to counsel, bringing somebody else in, again, that's a cost for the client. So trying to approach it in a really pragmatic manner. Depending how far through a process to trial is with a mediation, and depending on the quantum that's in issue, sometimes it is easier, and I have seen that issue sort of just being parked while we deal with the bigger issues and see whether we can get agreement on that front and kind of agree to disagree on that other thing, and we won't mention the S word. But it is really a problematic area we're finding at the moment.
Yeah. Dara, another question without notice. What are the 2 or 3 things you would love the full court to clarify for you in the light of Shinohara?
Well, I will preface this by saying, unlike the retired Honourable Justice Watts, who does not have consequences, I have consequences, so as I put on my armour every day. So I don't think there's any clarification that's needed. I think we're all doing great. Look, I suppose one issue that could be clarified is whether in adjusting in step 1, whether it's only the existing assets and liabilities of the parties that should be identified, or whether we can do other things. I think that is an interesting question that would be worth being clarified. Otherwise, can I say, I do think that the full court and the court is going to do a good job of this for us. There's a lot of talk, I think, in the cases that I've read, and there's grappling with how you deal with contributions versus future needs assessments. So I think we'll explore it quite a bit. So I think we're all doing our best.
Yeah. And I'd imagine it won't be a bad thing to revisit Shaun and Hopkins. There was few uncertainties came out of that, few arguments in the court around that. Yeah. So there will need to be, one or two more major cases, I think, to settle the future direction around these things.
I mean, it's interesting because if you think about what happened after Stanford, and after Stanford, we all got very nervous about what you do with ad backs. And then we had sort of vast to help us clarify that. So it's not necessarily the full or the high court that's going to clarify for us. It might be the high court that kind of tells us what direction to do, but then it's the full court, well, what is now Division 1 appellate jurisdiction.
Whatever.
Exactly. That does clarify for us. So sometimes the high court kind of, we don't have a family law practitioner on the high court, so sometimes it needs to trickle down to us. So they might confuse us more.
The great problem with the High Court is they read the Act. They say, what do these words mean? I'm going to skip a couple of questions because we've kind of covered them. And I'd like to go on to family violence. And our next set of polls, if I could, around family violence. Thank you. How often are you raising family violence as impacting contributions is the question. And the next one will come is, how often are you doing so as a matter of future needs? Okay, so that's the way we're trying to set that up. Okay, well, I think we're probably sufficiently allowed time for that. And you're seeing the majority is saying sometimes you're running a contribution argument. A contribution argument is not easy, and this is something we're going to get to, because the legislation says you've got to show the economic impact on contributions. But thank you for the majority, at least sometimes. Some people are doing so frequently, and that's interesting. 17% are doing so frequently, and others rarely. It does depend, of course, on your case mix. Let's go to the second poll. And this is now around Section 79.5, future needs. How often are you running DV in this context? Well, clearly the majority are saying both contributions and future needs. That's not a great surprise. Double dipping issues might be worth thinking about there. Can you argue contributions and future needs and not in some way reward the same thing? Not reward, sorry. I should say compensate, actually, the same thing twice. And then, 18% say mainly future needs. Let's turn back to the questions, and the question for you, Melbourne Liz, if I may. how do you demonstrate an economic impact on contributions or on current and future circumstances as a consequence of being a victim of family violence?
It can be difficult, and very much, I think, depends on the evidence in the case. There was a matter run in our office very shortly after Shinohara, whereby there was significant family violence both during the relationship and post-separation. But the ultimate finding was that the contributions of, in that case, the wife, were sort of made in spite of the conduct of the other party and, to her credit, which seemed a bit of a, unsatisfactory outcome for the client. But it is the case that for some people, it's hard to show that it has had that impact if, there's a kind of element of, well, I've got to get on with it. Really, the ways in which I've been able to do it, and I say successfully, none of the cases where I've made these arguments have gone to reserve judgment level settled, but have been in relation to a current diagnosis of PTSD and some quite good evidence from treaters about the likely time frame. The thing about PTSD is it's a slow recovery, and the treater in one of the cases, that it was a threshold issue, and it was about setting aside a BFA, but we were sort of running the substantive argument at the same time, and what that treater said was it's a minimum of 3 years, but it won't. That 3-year period doesn't commence until this litigation ends. And it was well known, it was a 20-year relationship. Had my client been successful on the setting aside, we just would have been essentially back to any standard separating couple taking probably another 2 years if we hadn't settled the matter. And so that evidence was useful insofar as there wasn't so much a question about whether the wife in time could earn money to support herself. It was more a question of, well, how long did she need in this recovery before that conceded income earning capacity could be available to her.
And if you get an expert on PTSD or whatever, presumably a psychologist or a psychiatrist, but there's a financial aspect to this. How do you prove or how do you calculate the economic impact into the future?
Yeah, I think the words of the psychologist when I first broached this with her was, she said, I don't have a crystal ball. So it does rely on, I guess, judgment and skill. But importantly, and I know of cases where there has been, as I said, a single expert that's not a treater. I think the difficulty with that is it's hard to speak to this particular patient before you. So you can make projections and predictions, but it's, I think, difficult to do it without knowledge of the individual and their circumstances.
And the financial aspects of that?
Essentially, the income earning capacity and the cost of the treatment are the two ones that I've argued. Yeah, because a lot of you get your 6 sessions, and I think you can get 2 lots of 6 sessions in a year. But for most of these cases, where there's been a really significant history of family violence, these people are in fortnightly treatment for years.
Thank you, Liz and Dara.
Yeah, I suppose it's interesting. So I've run a couple of cases where you can sort of quantify the economic impact on current and future circumstances. So one case where I've had a party's employer go on evidence for them, and effectively the party was employed part-time and was absolutely doing their best, but there had been a long history of family violence that very much impacted on her self-esteem. So in that case, I had the employer say, look, a full-time position is just not something that I think that this particular person could manage. That was helpful. I had another interesting case that went to judgment, and judgment was delivered on Christmas Eve, actually. It may be reported, I haven't seen it come out, but it might be unreported. But it was an interesting case where it was a long de facto relationship. There were no allegations of family violence during the relationship by either party. However, after separation, in one very unfortunate act, in that case, the wife owned a property that had a little sublet at the back, and she was renting it on Airbnb. And the husband, or the de facto husband in that case, called counsel and said, go check this out, I think it's non-compliant. And it was, and she could then no longer rent out her apartment or her little sublet. And in that case, the judge found, whilst this wasn't a contributions argument, this was effectively impacting on the current and future circumstances of the de facto wife, and made a 1% adjustment, which did, the judge didn't say this in her judgment, but it equated to 1 year of the rental income that had been received historically. So it was interesting that was how that issue was dealt with, but that's an easy thing to quantify. What rent have you lost? It was, as I said, an interesting case because there were no other allegations of family violence except for that one.
And again, this may be a Melbourne thing, Dara, but the definition of family violence just expanding and expanding, expanding. Again, you could have dealt with that in Section 7520.
Yes.
And I mean, it's just raised the concern that if you keep expanding what family violence is, it becomes meaningless. You lose the thrust of the most important cases of victims of very, very serious family violence. That's drowned out in the cacophony of allegations.
But
that's my concern.
I suppose, but has there ever, in my experience, and I'm happy to be told I'm wrong, but 7520 is never really something that was given significant adjustments for. It was the afterthought. So when it was bad behavior, it was sort of the afterthought, is my view on that.
There's what goes on in the judge's mind, and there's what makes its way to paper in the judgment, and the
Correct.
two are not the same thing. We're going to move to the final question, and it's Sydney Liz helping us start off. In some cases, both parties say they were a victim of family violence by the other. This can happen, for example, when heated arguments escalate into violence. Are you seeing such mutual claims in practice? And how are you handling them?
Look, I think there have always been instances of mutual claims, but because of the increased focus, the changes last year, all of the things that we've talked about before, I think there's certainly more of them that are having to be navigated through. The other point that I completely agree with what Liz and Dara have said in terms of the economic cost and what's flowed from the changes. The other point that I just wanted to make, which does tap into this, is there are additional considerations that arise if, for example, you are acting for a victim survivor and the perpetrator is self-represented.
Yes, yes.
And one of the big issues, I remember at the time that the exposure drafts were put out, and even when the EM was introduced, that the government had said there'd be no financial impact of the bill. That simply cannot be the case where, for example, if you are putting greater influence on family violences, things like funding for legal aid, the domestic violence service provider sector, the cross-examination scheme, they are all going to have budgetary considerations that come back to how do you challenge evidence that is being put before the court by a victim survivor or a perpetrator. So I think this is another example of where the rubber really hits the road and these issues are going to come together. It may be that as we move to kind of the close of the first year of the reforms, when we move back into Commonwealth budget time, that we actually hear more about this when courts and legal aid providers are able to look at the figures and say there has been an increase in people seeking access to legal aid in these kind of circumstances.
That's a really interesting point, and it's clear the government completely underestimated the changes in the parenting side from having to fund cross-examination in those circumstances. Thank you for that point, Liz. Now, Dara, can you tell us about the paper which you've written with some help from...
Yes, so it's hopefully helpful. It sort of evolved because when I had started writing it, there wasn't a lot of cases, but it has some points on the cases and some just things to think about. But hopefully, if nothing else, it has a few references which might be interesting to look at in terms of some judgments on how the court is dealing with contributions, future needs, post-Shinohara, that sort of thing.
Thank you, Dara, and I gather that's going to be mailed out to everybody or emailed out after the conference. So can I thank my colleagues here very, very much for their thought involved with this panel. Thank you.
Thank you so much for that insightful session. We'll now break for morning tea, everyone, and we just go back behind there. Thank you.